Luxury jewelry maker Tiffany Company sues Costco for selling Tiffany diamond rings. I'm going to take a look at this trademark war. I'm Angela Langlotz. I'm going to spend the next 4 minutes discussing this case. If you have trademark or copyright law questions, drop them into the comments below. I'll answer them on a future live video. So, luxury jewelry maker it's toward the end of the week, I'm stumbling. Luxury jewelry maker Tiffany sued Costco. Why? Because Costco was advertising rings with a Tiffany setting. So Tiffany, always very jealous to protect the cachet of its luxury jewelry brand, didn't want their brand associated with discount big box store Costco. So they sued. The lower court judge said, Costco, you're out of line, you gotta pay. Costco appealed. The appeals court judge said, well, consumers are smart enough to recognize that the goods that Costco is selling are not Tiffany goods, but that the setting is a Tiffany setting. So this really hinged on whether or not the term Tiffany setting was sort of generic for a certain type of setting, or it was unique to Tiffany. Let's have a look. So I went and I Googled, what is a Tiffany setting? And this is what I found. When people talk about a Tiffany style setting, they're talking about the single diamond raised up and held securely on top of the band by slender prongs, usually 6, but sometimes 4. So it looks like the term Tiffany setting has become in our culture sort of generic for a certain type of presentation of the diamond on the ring. It's not set down, it's raised up on thin prongs, and that's what Costco was describing when they're talking about a Tiffany setting. They were not trying to say that the goods were Tiffany or that they were endorsed by Tiffany or that there was some sort of relationship between Costco and Tiffany, God forbid. They were trying to describe the type of setting that the ring had to distinguish it maybe from other types of settings that were different. But nonetheless, Tiffany got upset about this and they went to court and they spent probably hundreds of thousands of dollars fighting about this. Now, this is a good lesson for any trademark owner. What are the lessons here? Number one, you really need to enforce your trademark rights to prevent them from becoming generic. So Tiffany didn't really enforce their trademark rights, and now apparently a Tiffany setting is this sort of setting. Now, that's Tiffany's fault. That's on them for not taking care to distinguish their setting and the name for the setting as being exclusively theirs. They allowed other people to use it. The other thing that we can learn from this is that if you are using other people's trademarks to describe your goods, that's a dangerous thing to do. I advise you not to do that, because what can happen is the trademark owner can get pissed off and come and sue you, and you're going to have a lot of time and money invested in fighting that lawsuit. The safer thing to do is just not use other people's trademarks, or to be very sure to say somewhere on your sales page or in your sales material that this trademark that you just used to describe a something is not your trademark, and that it belongs to somebody else, and that you don't have any relationship with them, and that you're just using it to describe whatever you're describing, right? But the better practice is don't use it at all, then you never have anything to worry about. I'm Angela Langlotz. Find me online at TrademarkDoctor.net. I'm on YouTube at video.TrademarkDoctor.net/YouTube. I'm also on TikTok. I'm making short videos there. It's kind of a new thing. So you can find me there at Trademark Doctor, and I'm also on Facebook at facebook.com/Trademark Doctor. Drop questions into the comments. I'll answer them on a future live.